YH Liman. I appear with MN Sadauki for the first defendant, my lord. First respondent, sorry.
YH Liman and
MN Sadauki. For the first respondent, my lord.
Yes.
With most profound humility and greatest respect, sir, E.A. Adeniton is my name. My lord, I'm holding the brief of J.J. Usman S.A.N. for the second respondent. My lord, the learner's sake has asked me specifically to convey his apology for not being able to come. He was unable to do so on health ground. He has been down in the hospital. So he has asked me to communicate his apology for not coming in this matter formally himself. May it please my lord.
Yes. Mr. Musa. He has disappeared from the screen. Yes, we're waiting for you.
We have before this honorable court. Yes, my lord. We have before this honorable court an application dated and filed 2nd November 2022. It is brought pursuant to the orders on its face. The application is supported by an affidavit.
Are you sure?
Sworn to by the applicant himself. My lord?
I'm trying to have a look at the, yes, go ahead.
Yes, my lord. The application has annexed to it 3 affidavits, one by the applicant, one by the Senator Umar El-Gash, the chairman of PDP in Yobe State, and one by Ahmed Waziri, the legal advisor, Yobe State, PDP. We humbly rely on all the affidavits read to save the time of the court. Because the prayers are set. And next to the application, which we humbly adopt at this. We also have before this honorable court a further affidavit post
Mr. Musa. Mr.
My
Musa.
Lord, I must apologize. It appears my network had an issue. I've changed the network now from MTN to Glo.
You said you have a further affidavit deposed to by?
We have before this Honorable Court a further affidavit deposed to by the applicant. Today, which was filed yesterday online and today in hard copy. My Lord.
Yes.
Annexed to that further affidavit is a reply address yes, along with the exhibits. My Lord, we seek to adopt the reply address as our further argument in this matter. My Lord, we haven't adopted both our address in support filed on 2nd November and the reply address filed 6th November. We do not intend to add at this point. We humbly pray this Honorable Court to grant our application most obliged.
My Lord, on behalf of the first respondent, we have filed a counter affidavit of 4 paragraphs and a written address dated the 4th day of November, my Lord, 2022. We rely on all the averments in the counter affidavit and our written address in urging my Lord to refuse the application. My Lord, we want to briefly, my Lord, we should draw the attention of my Lord to one important fact, just very briefly. My Lord, the applicant sought to appeal as an interested party. So the number one burden on him is for him to show that he is indeed a party with interest. If my Lord looks at the counter affidavit and the further affidavit filed by the applicant, my Lord will see that 1, there was no expression of interest to contest for the office exhibited by the applicant. Expression of interest form exhibited by the applicant, 1. 2, there was no nomination form by the members of the party nominating him as a candidate or as an aspirant to contest for the said primary election. Three, there was no election, there is no election result to show that he emerged the winner of the said primary election. And four, my lord, even if he was the sole candidate unopposed, there must be vote of at least one person to show that he was voted.
Your last one, four, what?
Four, my lord, even if he was the sole candidate for that purported primary election, there must be vote to show that he was actually voted by at least one person to show that he was actually voted for. There was none, my lord. So, my lord, all this goes to show that there was no primary election conducted on the 26th day of September 2022.
On 26th.
26th day of September, my lord, 2022, as allegedly claimed, my lord. My lord, if my lord looks at the only thing that is annexed to his application is a membership card. It's a membership card. Yeah.
Yes.
So, my lord, the membership card does not give, does not and cannot vest him with any interest in this matter. We therefore, my lord, lastly, the list of delegates, list of people that was annexed to the counter affidavit is just a list of ad hoc members without any explanation. Ad hoc delegates without any explanation, my lord.
Yes.
Therefore, most respectfully, my lord, submit that the applicant is not him but a busybody, and we urge my lord to refuse the application with substantial cause, my lord. That is our humble prayers, my lord.
My lord.
My lord,
Yes.
my lord, on our part, we have not heard any process. We have not filed any process on behalf of the second respondents. Put differently, we do not oppose the said application. May it please your lordship.
My lord.
Yes.
With the kind permission of the court, may I respond to the
Yes, go ahead.
Yes, I want to first of all say that I'm taken by surprise. These arguments are not in the address. I would have brought authorities to address them. Court cases, had they been in the address?
Counsel, you need to, okay, yes.
You
see it, you have been taken.
I said I was taken by surprise because these arguments are not in the written address of the first respondent.
Yes.
I would therefore ask the court to discountenance them. Because the era of taking an opponent by surprise has passed. Be that as it may, my lord.
Yes.
In the event that the court is minded to look at them, in the event that the court overrules me and does not discountenance them, I humbly submit as follows.
Yes.
The first respondent has not given any basis or quoted any law or rule or foundation for the conditions he just listed. Talking about nomination form, expression of interest form, vote tally, result sheet, and so on. And also saying that the membership card is not enough. A lawyer cannot give evidence. And I dare say a lawyer cannot make law. every submission of counsel must be backed by law or by evidence. That is why the first respondent filed a counter affidavit, which is evidence. And a written address, which is the law. There is nothing in any of those documents filed by the first respondent that refers to any of these conditions he had just raised from the bar. Counsel cannot viva voce impose conditions on the applicant. Because the law is that what is based on nothing must collapse. That is why the law says there must be a foundation. May I therefore refer this honorable court to section 84, subsection 7 of the Electoral Act 2002, section 84, subsection 7 of the Electoral Act 2022. With the kind permission of this honorable court, I humbly pray to read this section. Most obliged.
Go ahead.
Most obliged, my lord. It says, where there is only one aspirant or a consensus candidate in a political party for any of the elective positions mentioned in subsections 5A, B, C, and D, the party shall convene a special convention or congress at a designated center on a specified date for the confirmation of such aspirant, and the name of the aspirant shall be forwarded to the Independent National Electoral Commission as the candidate of the party. My lord, what this section stipulates, the only burden is that there should be a congress, and the only thing that should happen the only thing that should happen at that congress is a confirmation of the aspirant. There's no condition, none of the conditions listed by my learned friend is mentioned in section 84(7) of the Electoral Act. We therefore urge the Honorable Court to discountenance the argument or those conditions, the argument that those conditions were not met by the applicants. My Lord, may I go on? I can't see my Lord anymore. May I go on?
Yes.
Okay, most obliged. With regard to the submission of my learned friend on the list of delegates, he said that the list of delegates was dumped on the court with no explanation. The applicant has said that that was the list of delegates at the special Congress.
Yes.
Where he was confirmed. So the list was not dumped on this honorable court without explanation. That is the explanation. My Lord, the applicant's affidavit and all his facts have been verified by the chairman of the party. In Yobe State. And the legal advisor of the party. We humbly submit in conclusion that from the weighty documents and affidavits on oath, the positions on oath, the applicant has shown sufficient interest to be allowed in as an interested party. We are not at this stage seeking to overturn the judgment. We only want to be allowed to appear. At the Court of Appeal, so that we can be heard.
Mr. Musa, are you? Yes.
Yes, my Lord. So the question, therefore, is why? What is the first respondent afraid of that does not want us to be heard?
My Lord, this is not a reply on point of law.
So
it's
issue
just reopening. It's just reopening another argument again.
in conclusion,
Yes, sister.
we just want to be allowed to be heard in the interest of justice.
Yes.
And not to be shut out, as the first respondent wants us to be shut out. We are not saying we will win the appeal. We don't know. All we say is we want to be heard. We want to test, with due respect, the judgment as interested parties. And we therefore humbly pray the Honorable Court to grant our application in the interest of fair hearing. Since we were not heard during this matter at the lower court, and this Honorable Court, we humbly pray to be allowed to be let in so that we can be heard at the Court of Appeal. Most obliged, my Lord. We are very grateful.
My Lord, even if it is on record, I just want to, because while replying on point of law, my learned senior has raised some new issues. So even if it is off record, I just wish to draw the attention of
My Lord,
Lord.
I'm sorry, my learned friend does not have the right of reply. If he had just adopted, I wouldn't have had anything to say. But he took me by surprise and I've replied. And I don't want him to take me by surprise because then I have to reply again. And we will not be able to finish these proceedings. This is not regular, my Lord. I have spoken, he has replied, and I've replied to him. I humbly object to allowing him to speak unless I'm allowed to speak again after him.
My Lord, if indeed I have taken him by surprise, as he rightly pointed out, it means I first spoke, he responded to my own argument. So I have the right to respond. I have the right to take the last bite. And my Lord, what I need to do is just to draw the attention of my Lord.
I would like my Lord will rule on it. I'm objecting.
My Lord, if my Lord rule, my Lord, even if it is off record, I just wanted to, and even after this court has adjourned this case, if there is a law or there is an authority, we can submit it to the court. Just what we're interested is justice. It's not some technicality or.
Gentlemen, can you both hear me?
Yes, my Lord.
My Lord, we are with you, my
I
Lord.
can hear you, my Lord.
Okay.
We are with you, my Lord.
Ruling.
As a pleases.
This honorable court, having listened to all learned counsel in this matter, will adjourn to tomorrow, the 8th day of November 2022, to deliver a ruling in respect of same through virtual means by 2 o'clock.
As a court pleases.
2 p.m.
As a court pleases.
Thank you. Okay,
Most
thank you,
obliged,
gentlemen.
My Lord.
Thank you,
most
Mr.
thank my Lord. We must thank my Lord for treating this matter with the urgency it deserves. We are very, very grateful, my Lord. Most obliged, sir.
Thank you.
I'm most grateful, my Lord.
Documents da yake magana su ne kamar da su exhibiting din shi even without a counter this application would do it saboda ba su exhibiting din su ba I need the authority in section 243 That's what shows his interest. Those documents. So, my whole section example da yake cewa maganar confirmation. Akwai confirmation din ne? There's no confirmation for it. Oh, sorry.
Oga, how are you?
So my lord is still